Sorry.
Ma'am, you're charged with assault, bodily injury. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Thank you, Your Honor. On April 17, 2025, in Harris County, Texas.
Wait, let's slow this down. Assault causing bodily injury in Texas isn't just a slap on the wrist. It's a Class A misdemeanor, meaning it can land you behind bars for a full year and cost you $4000. Now ask yourself, should physical altercations between neighbors always go straight to criminal court? Or are there situations where a warning should be enough? Drop your take in the comments.
Officers arrived and spoke with the complaining witness, who stated her and the defendant are neighbors. The complaining witness stated the altercation was only verbal until the complaining witness exited her apartment unit and observed the defendant approach her while calling her names. The complaining witness states that the defendant then struck her 3 times on the head with a closed fist. The complaining witness stated a witness was able to separate them. The complaining witness exited her apartment unit approximately 1 hour later, at which point the defendant approached her again while stating that when the defendant was in jail, she heard the CW was talking bad about her. The complaining witness stated that the defendant then struck her on the face and head with a closed fist 5 to 6 more times. The witness stated he observed the defendant pulling the complaining witness's hair, but did not witness any striking or punches thrown. The officer observed a light red mark on the complaining witness's cheek.
Any alcohol?
Take a closer look here.
Ms. Simmons, I'm going to find if there's sufficient probable cause to go forward with the case. I'm going to tell you now that I will do everything in my power to protect my community at all costs.
Oof, that's a lot. 2 separate alleged attacks, multiple punches, and a neighbor feud turned violent. But here's what makes this tricky: conflicting witness details. One says hair pulling, the other says closed fist punches. In cases like this, perception and perspective matter. Who do you believe?
I don't know what kind of resources you have here, but if you don't have anyone to pony up $5,000 to $10,000 if I revoke your bond, you will be stuck like Chuck in there until this case is over. Do you understand?
Yes, sir.
I don't want you to consume alcohol or illegal drugs, and I don't want you to have contact with the complaining witness in this case. I don't want you to go within 500 feet of where she lives or where she works. You understand?
We live right across the hall from each other.
Don't want you to go anywhere near her. I don't want her to be in fear when she's trying to get home.
I understand.
Yeah. Actions have consequences, and I don't want you to go anywhere near where she lives or where she works. You're also not going to possess your weapons as well.
Stuck like Chuck? Yeah, Judge Fleischer isn't pulling punches. If you can't make bond, you're sitting in jail until your trial. This is where the justice system gets real. Money equals freedom while you wait. Should your wallet decide your fate pre-trial?
Judge, after taking a closer look, it doesn't specify whether or not alcohol played a role in this event.
Do you have the ability to hire a lawyer, ma'am?
No, I don't. I need one.
Okay. I'll give you an application. We'll see whether you qualify. I need to know everything about you, how much money you have coming in, where from, cars, anything, money in the bank, and then we'll take a look to see whether you qualify.
All right, thank you.
Miranda's going to give an application. You will meet with Pritchard for your bond conditions, then we'll have you meet with someone shortly.
Okay.
For walking, you're charged with driving while intoxicated. Second offense. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to your service.
Thank you, Your Honor. On April 20th, 2025, in Harris County, Texas, law enforcement officers were dispatched to a report of erratic driving in a gray BMW sedan, nearly striking other vehicles. The law enforcement officer located the vehicle and paced the vehicle going 85 miles per hour and a 65 mile per hour.
Hey, don't talk. Don't talk. Can you start from the beginning, please?
Yes, Your Honor. On April 20th, 2025, in Harris County, Texas, a law enforcement officer was dispatched to a report of erratic driving of a gray BMW sedan, nearly striking other vehicles. The law enforcement officer located the vehicle and paced the vehicle going 85 miles per hour in a 65 miles per hour zone and saw the vehicle almost strike a delineator pole. The law enforcement officer initiated a traffic stop and made contact with the defendant. The law enforcement officer observed a strong odor of an alcoholic beverage, slurred speech, red glossy eyes, swaying, and unbalance from the defendant. The defendant admitted to having 2 beers prior to driving, or 2 alcoholic beverages unspecified prior to driving. Standard field sobriety tests were conducted, a 6 out of 6 on the HGN, a 5 out of 8 on the walk and turn.
Blow numbers like 137 and 127? That's more than buzzed, that's blitzed. In Texas, anything over 0.8 is illegal, so he's clocking in nearly double. Second offense means no mercy, but here's the real kicker. Should breathalyzer results be enough to override all defenses?
The law enforcement officer found an open container of an alcoholic beverage on the passenger side floorboard, cold to the touch. The defendant consented to breath and blew a .137 and a .127.
Mr. Walker, I'm going to find that there's sufficient probable cause to go forward with the case. I am now taking away your ability to drive. You are not allowed to drive. Do you understand? You will be signing an affidavit with me today, promising me you're not going to drive. I don't give a rat's behind what your excuse is. If I find that you drive, I can have a contempt hearing. You could be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand? Because it's a second offense, I'm requiring you now to get a portable device that you're going to take with you everywhere you go to prove to me that you're not consuming alcohol. If I find that you do, I will put you in jail. No more PR bonds for you. Do you understand? You're not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. Does he have a license? Can you run it?
Yes, Your Honor.
We're going to reset your case to give you time to hire a lawyer. So I'm going to have you come up here, swear it does that you're not going to drive. I'm going to get you to Victoria where we will have you sign a reset. You will then get with pre-chop for your bond conditions, and after that you'll be free to go. When you come back, please have a lawyer. Please.
Judge.
Oh, hold on, Vic. Let me tell Mr. Walker one more thing. Come up. I am placing a restriction on your license. You are not allowed to drive any vehicle that doesn't have an ignition interlock on it. I'm sending notice to DPS in Austin so that every single officer in the state knows that if you're in a vehicle driving, that vehicle is supposed to have an interlock on it. If you're caught and you don't have one, they will take you to jail. As it stands now, as part of your bond conditions, I'm warning you not to drive for the time being. Do you understand?
I got one.
Look, it's not, I'm just, no response is required. I'm just telling you what the expectations are. And if you violate these conditions of bond, I will revoke the bond and I'm going to put you in jail.
I know I was trying to get a real good understanding. That's why I want to ask the question.
You need a lawyer. I don't want you to ask something. I don't want you to say something that hurts your case. We're going to give you time, please. All right. Good morning, Miss Arena.
Hello, how are you today?
We took you into custody, or we have you in custody now because you are on deferred for an aggravated assault of a family member. And a motion, I'm assuming a motion, let me make sure. Yeah, it looks like a motion to revoke has been filed, and you are at a bond denied status now, meaning that you're being held at no bond. So what we're going to do is we're going to do probable cause in this case here. We have to take you into custody. You will probably populate on Monday's docket for the felony court.
That's for what?
You're now charged with driving while intoxicated.
Now see, here's the thing.
Oh, did I ask you to say anything?
No, sir.
Okay, please. You have the right to remain silent.
Mhm.
Exercise that right. You
Yes,
may
sir.
say something that hurts your case unknowingly when you're trying to think that you're helping. Just don't.
Yes, sir.
We're going to do probable cause. Like I said, you have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. I'm going to appoint you a lawyer after we do probable cause to you. You can speak to someone here momentarily. Okay? So let's just do this real quick and then. Okay.
Thank you, Your Honor. On April 19, 2025, in Harris County, Texas, a law enforcement officer conducted a business check of an Exxon gas station. The officer observed a motor vehicle at the gas pump without a front license plate and with the brake lights on.
Start from the beginning, please.
Yes, sir. On April 19, 2025, in Harris County, Texas, a law enforcement officer conducted a business check of an Exxon gas station. The officer observed a motor vehicle at the gas pump without a front license plate and with the brake lights on. The officer observed a male asleep behind the wheel in the driver's seat. The officer contacted the defendant and observed him to have red, glossy eyes and a strong odor of alcoholic beverage emitting from his breath and his person. The defendant initially refused to obey verbal commands to exit the vehicle. The defendant then exited the vehicle and stated that he would not allow any deputies to detain him and would not perform standard field sobriety tests. The officer took the defendant into custody. The officer notes that the ADA accepted charges under no refusal and that a specimen was not needed.
Did anyone see him drive? He's sitting at a pump, he's sleeping. I mean, the officer try to go look at camera footage to see if they see him driving at all. Does anyone have him driving?
Judge, we do have camera footage from the Exxon recording the defendant driving into the gas station on the dim summary. Yes, Judge.
All I'm asking is, do you have something that shows him driving? Okay. Mr. Rain, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, it's not going to go well.
Yes,
You
sir.
understand? Just don't use alcohol or illegal drugs.
I completely understand.
Okay. Hold on. Does he have a valid license? Can you check, please?
Yes, Your Honor. I will check.
As long as you have a and then does he have any prior DWIs, I guess, as well?
There's no prior DWIs.
Okay. License.
And the license status should be ready for my review. Pulling up. It is. Trying to load up. It says it's eligible, Your Honor.
Great. Before you say something, let me please give you a lawyer, and let me have you talk to the lawyer, and then whatever issue you may have, they can come back and talk to me. I just don't want you to say something that hurts your case in any way. I'm trying to help you, I promise.
You understand?
Just don't. So go ahead, put him back. We'll give him a lawyer, but don't send him down because, are you ready for conditions? Okay, take your time. No rush. Okay. You are on bond for a tampering case, and you've now picked up a burglary of a motor vehicle. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Thank you, Your Honor. On April 14, 2025, in Harris County, Texas, a law enforcement officer was flagged down by the complaining witness. The complaining witness advised the officer that a male had just broken into the complaining witness's motor vehicle and drove off in a different motor vehicle. Another witness observed the defendant break into the complaining witness's motor vehicle and provided cell phone video to the police. Additionally, the complaining witness observed the defendant break into his motor vehicle and chased the defendant through.
Okay, here's where things get murky. Clothes changed, suspect detained, ID confirmed. But was it really him? The drive-by ID and missing details raise major questions. Ever wonder how often misidentifications happen in fast-moving arrests like this? Let's hear what you think.
The defendant was detained and positively identified by both the witness and the complaining witness. The defendant admitted to breaking the complaining witness's window.
How about day or night was this?
Closer.
Or was it during the day?
Here.
It's in the daytime, it appears, Your Honor, but also, like when you read the summary, it looks like an officer detained him on a bicycle and that he was wearing different clothes from the description of the foot pursuit, that clothes were ditched.
I don't know.
So then they did a drive-by identification of the suspect.
Mr. Robinson, what is the one thing I asked you not to do? The one thing I asked you not to do. Not be a danger to my city or pick up a new case. You've now picked up a very I'm going to find that there's probable cause to go forward with the case, and I'm now going to put a monitor on you so I know where you are at all times. If you get out of custody, because now I'm revoking your bond, you will go to jail. If he gets out, GPS monitor not to go within 500 feet.
He has a GPS monitor on
Putting him in custody. No alcohol, no drugs, no weapons, no going within 500 feet of where the complaining witness lives were. And I'm going to tell you now, because I don't know if you're going to get out, but if you do, you endanger my city again. I'm going to go ballistic on all of your bonds. Do you understand? Goes with you.
I have
Judge, I have no reason to doubt that,
Scott, just, there's no need. Son, every time you take off and when we revoke your bond, all you do is you're giving money to bonding companies. You just enrich bonding companies. That's all you're doing. I don't know if you got a lot of free money, but if so, I guess we'll stick with the conditions that we had before. Just no contact with the complaining witness, no weapons. So do you have an offer in this case now?
We do.
Okay, so we're going to set your case for trial today. You must appear for trial date 8:30 in the morning. Don't appear at 12, not at 1, and then we'll be set. I guess May. Let's see. Today's what? May 27th, okay with you?
Judge, that's a short week. Oh, yeah. June 10th or May
What time
20th.
do we have on the 3rd, Ramona?
I'm sorry?
What about the 3rd?
Victoria's out that week.
June 10th. Is June 10th a holiday week too?
Yeah, we can make it a holiday week.
No. June 10th it is.
No, June 10th, Judge.
Everybody's a comedian.
Thank you, Judge.
Voting.
Thank you. Thank you.
We're gonna have her side of the petition.
Alright, you ready?
Yes,
Yes, ma'am.
I picked up Mr. Mook's case today. I'm not sure how to pronounce that, but
That's right.
yeah, I think he left already. But I was wondering if we could rehear PC.
Hey,
Oh, he did? Oh, okay. I'm sorry.
I hope because I had asked him to reach out to the complaining witness just to make sure that she's okay.
Okay.
Is it she?
One issue there. So because it was resisting, it's not in our system. Contact information is not in our system. Now, when the office report comes through, it should be. Problem is we don't have that office report yet. I'm going to keep checking it. I can try to run through RMS.
I mean, until I know. Yeah, that's Mr. Mukes right there. So until I know, I'm going to order no contact because I don't know. Because she was scared of him.
Uh-huh.
So.
I understand. I was wondering if I could. I'm just approaching on PC for it.
Yeah,
But
Oh.
to rehear PC. Yeah.
Okay. Sure. Do you mind reading it again? Please.
Officers were dispatched to a disturbance call on April the 19th of 2025. Officers observed the defendant to be outside of the residence with what appeared to be an injured hand. Defendant stated he had injured his hand while punching a wall when he was in an argument with his wife. Defendant stated he was drinking, quote, Crown, and requested medical attention to the scene. Officers attempted to make contact with a female at the residence who refused to open the door. She only stated that the defendant should not be at the residence and that she was in fear of the defendant. Defendant advised that he would leave the location and return at a later time. Later on that day, the defendant contacted Precinct 7 dispatch and stated that he was going to kick the door down at the aforementioned residence. Officers returned to the location and made contact with the defendant, who stated that he was going to kick the door down as soon as officers left the location. Due to the defendant's apparent intoxication and the danger he posed to himself and others, officers attempted to place the defendant in custody for public intoxication.
Here's my problem. I didn't have a problem until that point.
Right, I understand that, Your Honor, but if the police are arresting him for public intoxication, the front door is not a public place under the statute, or under case law, or under the
No, it's not.
definition. It doesn't
That's
matter.
right.
It doesn't matter. It doesn't fall within the definition of a public place. Public places are where multiple people go through. They're common areas. It's not a public
He's
place.
not in his house.
It is his residence. It's
No,
his
he's
residence.
outside.
He's outside. And I would argue,
He's
Your Honor,
outside. He's not inside the house. He's
He's
outside.
right at the front door, and so
I mean,
Your Honor, I would argue a mailman goes to the front door, the leather packer goes to the front door.
I don't think under the statute it qualifies. I mean, I
show
have,
me a case that says
sure, I have the definition.
or is,
Right, I have the definition of a public place under the
you know what
Texas
the
Penal
definition of
Code.
a public place
It's
is.
like
Should-
apartments, hospitals, libraries, schools, office buildings, sidewalks, like driveways, the public road, not the front door. I mean, even the police, like, there is a reasonable expectation of privacy of going into the front door of the house. Like, it's not really considered a public place under the statute.
Show me case law, 'cause I don't know. I mean,
This debate right here? It's gold. What is a public place under Texas law? The front porch? The driveway? The curb? Turns out, it's not that clear-cut, and this ambiguity can make or break public intoxication charges. Have you ever thought about where your private property ends legally?
I'll try. I can find.
I know what I know the definition. I've seen the
Right,
definition,
yeah.
right? But show me something that says that a being, near the front door is private property, so it's not.
I mean, at the front door. I mean, that is like. I mean, people have a reasonable expectation of privacy in their home. Like,
In their home.
right.
Yes.
And at the, like, even at the very, like, front of the door. I mean,
We don't know exactly where he is.
but that's what the DIN says.
Your Honor, what I would say, he's clearly not in the house, he's at the front door, he's threatening to kick the door down after they had just gone out on a domestic-related call. And she said he appeared to be intoxicated, the defendant himself told officers that he was drinking Crown. They decided that based on the facts, he was a danger to himself, they decided to put him in custody for public intoxication.
Mr. Mukes, coming up.
I'll turn the live stream off.
Martinez, Regina?
Yes, sir.
Yes, sir.
Yeah, no, that's, I mean, Brenda wants to, I would can't. She's gonna have comments. She's not calling. She can find out.
The message is also get a quarter by how you get here each day.
You know what I mean? So, you let her know. If mom doesn't have to contact her, doesn't let her know to come in and get work, you can make them bond it. Yeah, I'm not, hey, let her know we're not gonna play games. I don't care.
Mr. Marlon Simmons, Your Honor. This is was a DWI PTI that went south.
18. It was remote.
Why for a plea?
Was tested positive for THC and alcohol, and they just reached a charge out of Waller County for operation of a salvage vehicle on a public roadway.
Okay, so this case is 517 days old. Do you have an offer on the case?
Yes, Your Honor. This was a 12-month probation since it came out of PTI.
Okay, so you must either accept the plea bargain from the state or I'm gonna set your case for trial today. So they've offered you a 12-month probation. You talk about it with Mr. D and see if that's something that you wanna do, because I don't know. Is that the
He's
only
got it.
offer you have?
That's the offer I made, yes. That's the
Okay.
offer for now.
So,
Now, he's already spoken with me, Judge.
so you let me know what you wanna do.
The plea is ready for right up there.
Yes.
Yes, sir.
Oh, I didn't realize.
Yes, sir.
Okay,
That's straight probation, Your Honor.
I'm going to tell you now that we've repeatedly asked you, we've repeatedly ordered you not to use. So you either don't care about the bond conditions or you got a problem. And I'm going to tell you now, we put someone in residential treatment kicking and screaming that they didn't want to go yesterday. So if you continue to test, I can modify your conditions to put you into an inpatient treatment program at a minimum of maybe 3, 6, 9 months, maybe a year and a half, depending on how well you respond to treatment. Do you understand? So, and I'm telling you now, I will test you like crazy. The first instance you use, it's not going to go well. I will issue a warrant for your arrest. We will have a hearing if they prove it to me, because I'm not letting you go until the act is clean. Do you understand me, Mr. Simmons? This system will not fail you. The agreement that you have worked out is 180 days in jail to be probated for 12 months. As part of the agreement, you will do a DWI education class, 2 victim impact panels. Have you done a TRAS yet?
They recommended supportive after 15.
Was that the way?
Okay.
Let's do a new one.
Stop it.
Substance abuse treatment as required by the TRAS. No breath test refusal, meaning that if you're pulled over, an officer asks you to take a breath test, you must do it while you're on this probation. No drugs, alcohol, and a guardian interlock.
Judge, with respect to the guardian interlock, client has informed me that he does not have a vehicle at this particular time. So I would respect request that the court allow him to use the portable device in lieu of the guardian.
I'm okay with that, but I'm telling you now, Mr. Simmons, that you will be signing an affidavit promising you're not going to drive. I don't care what your excuse is. Holy Mother Mary comes from and asks you for a ride from church. You drive. You can be facing an additional 6 months in jail on a contempt and a $500 fine every time you drive. Do you understand?
Sure.
Do not drive. Is it because he doesn't have a license?
He does not have a vehicle, he informed me, Judge.
Do you have a driver's license?
Sir.
Okay. We are sending notice to DPS so that every officer in the state knows if you were in a car driving, you were to have a guardian interlock, a breath test device. If you don't, you're caught driving a car. They're going to put you in jail. Don't be sneaky. Do you understand? You're giving up the right to a trial, right to compel witnesses to testify on your behalf, to confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal once you accept this agreement. You can never change this. The other thing, Mr. Simmons, is this now will reflect as a conviction on your record. You ever get pulled over in the future, be it 20 years from here, 30 years, you even have the faintest smell of alcohol or dope, they're going to see this DWI. It's probably not going to go well for you. Do you understand? How do you plead to the offense of driving while intoxicated? Guilty and I'm guilty. I'm going to find you guilty. I'm going to send you to this agreement. Good luck to you, sir.
Thank you, Your Honor.
Thank you, Mr. Speaker.